prosecution for that matter, and certainly exposes operators for any incidental take that may occur. The PNHP program is how we do that. This is actually a direct copy and paste out of our 102 regulations. The critical habitat is really a threatened and endangered species act term, or it's actually been designated as such by the federal government or perhaps the state agencies. So failing to satisfy that statutory obligation is really not an option for the department. And the process by which we have to do that is this program. When we talk about critical communities, if you look down to FIV, just down there, we are defining them to meet special concern species. This is consistent with the department. Every form policy that I've ever read on the subject describes special concern species as those other critical communities as listed in the law. So this is not a change in the department. However, we must nonetheless consider any potential impacts on these species. And what we have done is decouple that ability to consider from the PNDI process. It is a process that can be used, but other information could be provided to the department, perhaps as well, and giving the jurisdictional agency an opportunity, afforded them an opportunity to comment on it. And one of the things I thought about while we were drafting this is like timber rattlesnakes. And I've heard this comment from operators in the past that I am in this kind of habitat. I get a hit on PNDI. I write to them and I say, this is what I'm going to do. Here's my rattlesnake plan or whatever. And it takes them many, many months to get back to me, and they say, yes, do the plan. So I knew what I needed to do because I've done it 100 times before. But the process of the review was just simply delay. It did not add anything for environmental protection purposes. So that was an example I thought of in my mind where an operator could propose mitigation measures given the agency an opportunity to consider and comment on those measures as an alternative process.
Can you address immediately before that indeed it may adversely impact in terms of that being the standard by which actions will be judged?
Well, you got to hit.
You're talking about it in detail.
Correct.
Okay.
So from the department's perspective, we have a statutory obligation to protect threatened or endangered species and their critical communities, and we have one way of doing that, and that is this National Heritage Program. Species of special concern do not rise to the same level of protection. Obviously, the Oil and Gas Act requires us to consider these things. It's in our determination that PNDI is not necessarily the sole vehicle by which that could happen. I actually think this was the same thing we were offering in the previous version, that you could go through there and that would be something we would accept, but you don't have to. But the law does require us to consider other critical communities, which is a term used separately from threatened or endangered species. In our opinion, and the department's long-standing position, it can only mean one thing, and that is special concern species. If it does not mean special concern species, I do not know what it means. Those corridors are actually demarcated on the appropriate maps. So, it's been a long time since I looked at it, but basically there's a dotted line down the ridge or whatever, and it's a bright line test. And these are the same phrases that have been used for many years.
Did you use the keyboard?
Well, I don't know that you have any, or you've been operating.
One clarification comment in F1, where subsection applies to the proposed well is located. We are talking about the vertical well here.
Correct.
So-
Well, correct. And what we ask folks to describe are the pad and access road.
Just to clarify this, can we make sure that we're talking about the service area so that somebody doesn't say the lateral is somehow included in that term?
How's that work?
That's fine. Okay, in little VI, we are talking about public water wells and public surface water intakes, correct?
And that's the new definition of water purveyor, correct, Liz?
Sorry.
So the definition of water purveyor is limited only to public water supplies. My next comment was all the way on page 13, but do you have anything on page 9?
Well, that's three, back up, double I. Uses of the public resources, is that readily available? I mean, is that on a website somewhere so the operator can access it? Look at it in his application, or does he have to come to the department and ask them for functions and uses of the public resource?
I don't know that every resource, obviously you're talking about a whole variety of potential resources that could be included here. So I don't believe that they are delineated down to a 5 acre by 5 acre block area. So I think that part of this is going to need to be a site visit by the operator to ascertain from themselves what they believe is going on and giving the jurisdictional agency an opportunity to comment on that description or potentially having a consultation with the entity that's charged with managing that limited resource to identify those uses. But
Well, a public resource could be anything from a little township or community park to I guess, a state forest or a state park, right? So I think there's some concerns there about somebody can identify that, the applicant can identify it, but how inclusive does he have to be in terms of saying what the functions and use of that are? He says it's a township picnic area or something, picnic area along a highway, I don't know. I mean, is that sufficient, or is there somewhere he needs to go to further delineate what the functions and uses are of that resource? I don't know how to clarify that or make it any simpler than what you've already done, except to say that the flip side could be a very simple one-sentence delineation may not suffice when it's submitted. Somebody says, well, there's got to be more functions and uses than what you're talking about here. And so how detailed do you need to get? And is there some standard by which somebody's going to come back and say,
well, one of the things, and then this is a great point, and that is that I think the kinds of discussion that we're having now really needs to be fleshed out in a solid guidance/instruction document for the form. One of my concerns with this particular regulation is that if we attempted to identify all of the various permutations of public resources that might arise and what you do about them, we'd have a very thick book indeed. And that's not the intention, I believe, of the legislature. So I think that by having some more discussion with some of the entities that are in charge of managing these resources as we develop forms to implement this provision of regulation, I think we gain a lot more of their insight and expertise as to how this process can be implemented in a streamlined way. But I'd like to have that conversation again in the context of developing the form rather than trying to get out all of these, particularly when you have to write it in regulatory language, right?
Yeah.
It's very cumbersome.
Yeah. Immediately below that, then, too, you talk about measures proposed to be taken to avoid or mitigate impacts, if any, but if you're getting an ESCG erosion sediment control permit, you're already addressing that, aren't you?
Well, I guess it depends on what's going on at the resource. If you're 50 feet from the playground, I don't know that an erosion sediment control plan would necessarily be all the things an operator might contemplate to avoid or mitigate any potential impact to a recreational area like that. So it could very well be that if you're in the middle of the state forest where they've got areas that are managed for sustainable cherry harvest, you could say, perhaps, that we pick this, out of this entire area, we pick this site because we believe that it has the least impact on the cherry trees for whatever reason. So I propose to do nothing more than what I've done here. So this section necessarily extends beyond the normal laws and regulations that the department implements. It is reaching beyond just water quality, earth moving, air quality, and the like. It's getting more into aesthetics, I think, if you will.
Yeah, I was just going to say, if you want to, we could break it out into other subcommittees where you're actually making full resource agency in and ask them how they.
Yeah, I think that's, keep that in the queue as a possible item for subcommittee discussion.
Are there any more comments on this section?
Oh, last line in G. Protect against probably harmful impact. I guess, is there a standard for determining probable?
Well, the regulations require the statute requires the department to develop the criteria by which it will condition permits to further protect public resources. And the term the statute actually uses is probable harmful.
Okay.
And I think when we talked about this, we looked at criteria as standards that could be used in a criminal or civil proceeding, honors of the evidence beyond a reasonable doubt, probable harmful. I mean, all of these. There is obviously some degree of subjectivity to them, but they are nonetheless used in far more significant legal proceedings than issuing a law permit.
With regard to that same paragraph, when the DEP talks about optimal development of oil and gas resources, is it relying on the operator to explain that, or does the DEP have criteria to assess
Well, I think there's got to be a balancing that takes place, that in order to avoid a probable harmful impact that we quantify as a value of $30,000, I will have to expend $600,000 on a well that will cost $100,000 to drill. So the economics are very much out of filter in that regard. That a public resource does not trump all else. We have to consider the value of the resource to be extracted as well.
Right, that's the question. Is the DEP prepared to evaluate the value of the oil and gas resource, or do you rely on how to explain that?
Well, that would be very useful, as a matter of fact, considering this will be a permanent and determined application process. And I think what you would see is during the back and forth on comments received is whether or not it would behoove the operator to put forward the economic argument.